and they had a good enough case to charge her with second-degree murder, then why did they need to have an additional evaluation 5 years down the track? Just, I'm a bit, no, you can't. I don't think you can either. I think the implication is Sarah told the friendly therapist whatever she needed to say, but didn't want to work with the therapist hired by the state. No, I don't. Well, the initial therapist evaluated her 4 years ago, directly after the incident, like that year. And they actually, when they did question her, they did ask about whether or not she believed that she was feigning symptoms and whatnot, because obviously these people see this shit all the time. And it was her testimony that she didn't. And, 4 years ago, Sarah did not know anything about Bader-Sprouse syndrome, so she couldn't have preempted that this would be the defense that this lawyer would go towards 4 years down the track. So in my brain, she can't pre-prepare for that. Does that make sense? And now they're 4.5 years down the track, her memory is obviously not as clear as it was then. Not that it was clear because she was totally off her face, but there's a lot of time passed. Plus, she's out of that cycle as well now. I just think it's unfair. It's two different playing fields. It's like, racing a horse when on a wet field as a dry field. Could be the best horse in the world in the wet, but come last in the dry. The variables are just, I don't know. I'm not liking the tactic behind it, the methodology. Does that make sense? They should have, like I said, if they thought that they obviously thought their case was strong enough for second-degree murder 5 years ago, and yet they only get her mental evaluation 2 weeks ago. Doesn't. I don't like it. And yeah, of course, she's going to have the complete opposite diagnosis and evaluation. She has to. Otherwise, she wouldn't be here. She has got a pearl necklace on, though. And, do you know what the difference, that the fundamental difference between men and women is the definition of the word facial. Just saying. I went there, yeah. Oh, it's past midnight. It's my mummy's birthday today. Happy birthday, Mumsy. I won't ring you. It's 10 to 1. Have I got any L room? Oh, I think I do. L. She doesn't look the type to have a pearl necklace, so does she? Said that out loud, yeah. That's right. Yeah. Yep. The Grinch. She does absolutely look like the Grinch. She does. You're right. Oh dear. Come on, Bri. Where's your comeback? given out 2 good ones, pearls and facial, right there. Come on, peoples. I hate how they always go back to the back of her head. I still think the other psychologist was more likable, personality-wise. Smile. Smile. No? No smile from you? I know what she's thinking about. She looks really impressed to be there. She's thinking, I could be earning $1,000 an hour with the client that wants to wear nappies back at my office. And I'm sitting here drinking water out of a plastic cup nonetheless. And who knows who's been in this seat before me? I should have brought my disinfectant. Oh dear, I'm terrible. I can help myself. Yep, she definitely looks bound up. I know that's where you weren't going. I'm going.
Members of the jury, thank you so much for your patience. I have a matter I have to discuss with counsel outside of y'all's presence. It may take a little bit more time than just our conference up here, and we don't want to have y'all just hanging out waiting for us to figure out what we're going to do next. So I appreciate your patience. We're going to excuse you to the deliberation room at this time. Please do not conduct any independent investigation or research as to the person, places, things, or charge involved, and do not have any conversations amongst yourselves or anyone else about those things, and we'll bring you back in as promptly as possible. Thank you.
He always seems to have a smile on his face, this judge, regardless. He's put up with so much. I used to say I wouldn't get out of bed for under $100 an hour. And I didn't.
Mr. Rowan, see if you can find me that portion of the transcript that we were addressing as to
throw me a bone.
Opinions and other depositions and anything in Dr. Warner's deposition that you believe we need to address regarding this opinion as it relates to PTSD.
Is it a Chick-fil-A burger?
It applied to every opinion she was going to express. It started on page 37, line 24. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? And then 38 is when she started talking about a generalized anxiety disorder, and that she was not for sure whether Sarah Boone had a generalized anxiety disorder versus if it was just an adjustment disorder to being in jail. And then she also mentioned in that same answer that Sarah Boone had some narcissistic personality traits, and that those were my 2 major diagnoses. And then I questioned her further about that. She explained again on line 17 about general anxiety disorder versus the adjustment disorder. and that I hadn't had time to fully formulate that opinion out. Line 21, I need time to go through my notes and think about it and process it.
Page. We're still on page 38?
38, line 21. I need time to go through my notes, think about it, process it. But I had other depositions, as you're aware, yesterday, so I had to prepare for those and go through that. So I have not had time to process all my notes. And I said on line 39, well, doctor, I'm trying not to inconvenience you. You know, we're set for trial October 7th for jury selection.
No, well,
Line 6, I anticipate your testimony would be until a little later. So we could discontinue the deposition and then reset it when you've got time to review. Because obviously I'm not going to want to take your deposition and you have other opinions that are not going to be covered. And then I asked, looks like Mr. J asked, what's your position? He said, conducting discovery after the jury trial starts is completely unacceptable to me. So that's my position. If she needs to issue a supplemental report, or if there has become a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once jury is sworn and jeopardy attaches.
mm-hmm.
And I say on line 23 of page 39, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. And then she said, but if that happens, I can bring that forward, and then you can add to your deposition at that point if my opinions change after having reviewed further. And I referred to Mr. J. Page 9 of 40, Mr. J says, I think we plow ahead. This is our time with her. Court reporter's prepared to give us a transcript by the end of the week. Something needs to be amended.
End of the weekend.
End of the weekend. If something needs to be amended, then she can A, issue a report. B, if we need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. And I respond on page 40, line 23. I'm not suggesting that, Mr. J. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnosis or opinions. Mr. J responds on line 4. Okay. What I'm understanding her to say is right now, there has been a previous diagnosis of an adjustment disorder in some of the records, and she just needs to review her records to see if she thinks that is the best diagnosis that she would give as opposed to a generalized anxiety disorder. And then the witness says, you essentially flipped that, Mr. J, upside down. You got that backwards. So we go on to page 42. Line 1, Mr. Owens. I agree. And Dr. Werner, just let the state attorney know.
Okay, but we're skipping a massive portion of 41 that addresses specifically opinions
Let me go back.
as it relates to generalized anxiety disorder.
Okay, the witness starts on line 15. So she's saying she has the generalized anxiety disorder, and I'm saying I want to review it more because Sarah Boone had disclosed to the doctor that she had been previously diagnosed with a generalized anxiety disorder. And so the Dr. Werner was considering that admission, but she was saying, I want to review it more to see if I think it's more of an adjustment disorder to being in jail, Judge. To being in the correctional setting right now.
Completely different.
Stressors that she is under right now as opposed to a generalized anxiety disorder. So Mr. J says on line 22, okay, so on this topic, if something new comes up, then we can address it. But if you have other topics to dispose her on, then I suggest we go on. And then page 42, line 1, that's when I say, I agree, and Dr. Werner, just let the state attorney know. I know that you may be, we are on short time. If you do review your notes over the weekend or whatnot, and formulate any other opinions, just let the state attorney know, and I will address it.
We'll address it.
And we'll address it. Line 7, the witness, Dr. Warner says absolutely. And then, do you want me to continue reading, or?
If there's portions you want to highlight for me, I mean, I have the transcript. I'm following along with you.
That was the general understanding that we had about all diagnoses, all opinions that she may have. And so she starts talking about the mental status exam that she gave her, and then she page 43, line A, she said she has narcissistic personality disorder traits. Or I asked that question, you know? That's how she answered. She goes through a little bit of that. And then paraphrasing, she talks about the grandiose.
Why is the witness still in the stand?
Criteria that she met. And then on page 45, I asked her what other criteria, line 1, would tend to indicate that she was a narcissist.
Just saw that.
I didn't say that she was. I said that she has narcissistic traits. And that was the examples. That was,
excuse me for interrupting, but can we lasso this back into?
I understand that's what the depo reflects, but the non-objection which led to objection pertains to an opinion specifically about post-traumatic stress disorder. And at this time, no opinion is being referenced, nor does the call of the question pertain to narcissistic personality traits or diagnosis of narcissism. The question pertains to PTSD.
all right, page 46. Line 1, question, okay. Do you feel like she suffers from post-traumatic stress disorder? Line 3, answer. She didn't give me criteria with regards to that. She discussed having fear and anxiety of his family and fear that they would come into the jail or have someone else come into the jail.
Yeah, it's a completely different situation.
And she spoke about, you know, having recollections, remembering abuse from George during the evaluation. Question 13.
You're trying to rush this through.
On 46.
What was it? 4 days before the trial
You don't
started.
believe that she suffers from post-traumatic stress disorder, in your opinion? Answer, line 15. No. I would have to look back through my notes to see if she fully met the criteria.
So she hasn't fully
Question
evaluated
line
her.
17. Can you explain why you don't think she suffers from post-traumatic stress disorder? Answer, line 19. No, I didn't say one way or the other. I would have to look back through my notes for that. Line 21, question. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? Line 24, answer, I may. Number 25, question. Okay, and that's something you will let the lawyers know about if that changes? Answer, line 2 of page 47, yes. That's specific to the post-traumatic stress disorder.
Okay.
So at the time
And she
of
hasn't let them know.
deposition, when I asked her specifically,
So what's the legal objection? What are the legal grounds of the objection?
I would not take that deposition, Judge. When she said, I have not had time sufficiently to answer these questions, these diagnoses, these opinions, if this wasn't set for a definitive date that you had already told me it's not going to be continued, I would refuse to take that deposition. But under the promises from the state,
What are the legal grounds of your objection? I'm familiar with the background. I'm familiar with the time frame. I'm familiar with all the dates and the depots and the coordination and everything we had to do to get this all teed up before trial. What are the legal grounds of your objection?
She hasn't got the full information.
I understand the backdrop.
to give a diagnosis one way or the other.
I mean, I don't know if there's a legal ground other than we had an agreement as attorneys, as parties, that I would be notified of a change of opinion and I would be allowed to take a second deposition. That's the only thing I know to object to.
Okay.
Because I was not given that opportunity, which was an agreement between the parties.
Response.
Judge, I don't appreciate the implications that they're making. What I would proffer with this witness is, we spoke yesterday. I asked her if she had any change in her opinion about any of the diagnoses. She said no.
But she hadn't diagnosed it.
I asked, well, then my position, my understanding of her position is that it doesn't matter whether she had PTSD or not, because what Ms. Boone said at the time was that she zipped Mr. Torres up into the suitcase. They were both laughing. And once he was already secured in the suitcase, she became angry and then did all the things that she did. My expected answers from the doctor, based on a very brief conversation yesterday and this morning, was that if I asked her whether or not PTSD or BSS had anything to do with this particular case, that her answer would be, it doesn't matter because of what she stated happened.
Rubbish.
I'm not
The
asking her
response
about
was
her
the
diagnosis.
response to that, her behavior response to that stimulus would absolutely change because her perception is different. It does matter.
Diagnosis of PTSD. I'm not going to be going into narcissism. I'm not going to go into whether or not she ever delineated the difference between adjustment disorder or anxiety, because
I think she absolutely has adjustment disorder. Who wouldn't going into jail? That would be in addition, I would think, to what she's experienced. And as far as PTSD goes, you know, there's been no triggers. There's been nothing. So that dissipates a bit. So the level of hypersensitivity to that trauma response has diminished a huge amount in 4 years. Yeah. And now what is facing her at the moment is the adjustment disorder, because that's what is her, that's her environment. That's where she's at. It's
my understanding of what she told me was that none of this matters. None of this matters because
hers
of what
or
she said
the
to
prosecutors,
us
Edith?
during the evaluation.
But the question was, and I may have to ask Madam Court Reporter to read it back, but my memory of what the question was is, have you formulated an opinion with regard to PTSD?
And
And
my
she
expected
hasn't.
answer was, it doesn't matter because of what she said during the
Bullshit.
evaluation.
Okay. Unfortunately, that was not the answer that came from the witness.
Mhm.
The answer was a
But that's not
definitive
the
no.
state attorney's fault.
I'm not casting blame. I'm just going back over of what was asked and what was said.
Yep.
Okay.
Yes.
Judge, and that's his position, that post-traumatic stress disorder, that doesn't apply in this case, and that he, I'm sure, reflected his opinion to the expert. But that doesn't mean that that's my opinion, that post-traumatic stress does not
Okay,
apply.
that's irrelevant with the purposes of this argument.
Well, their discussions and him feeling like it didn't apply.
Okay. As an officer of the court, he just told me he spoke to the expert yesterday and the opinions hadn't changed.
But she
And the
answered
opinion that was
differently.
offered at the deposition was, I'm not sure. And based on what he had proffered as to what he expected the answer to be, the answer was not going to be any different. It's not applicable. It doesn't matter because of what she told me. That's unfortunately not the answer that was given.
That's all right. So
So
she
what
was
is it that you're asking me to do at this time, Mr. Owens?
strike it.
I'm asking, I don't know if we need to proffer the entire testimony of this witness, because opinions and diagnoses have apparently changed. I think I have a right to take a second deposition before she testifies.
What other opinions, Mr. J, if any, are going to be offered by Dr. Warner?
May I just proffer?
Yes.
All right, you've been present for all this hearing, yes, doctor? Am I misrepresenting any of our conversations?
No.
All right. And so if I ask you if battered spouse syndrome or PTSD has any
What the
relationship to the facts of the case as the defendant relayed them to you, what would be your answer?
That it's not related to the incident as she reported it.
And if I ask you, therefore, if there were any prior instances of violence, would that change your opinion? What would your answer be?
No.
And if you reviewed any other materials, would
Materials.
that change your opinion based on what she told you about what happened that evening?
No.
That's it.
Judge, number one, she's given a legal.
How can you say that?
Number two, it's a discovery violation.
How can you
What
say
is
that
the
if you had
legal
offered
opinion?
more evidence that
The
your opinion
post-traumatic
wouldn't
stress
change?
disorder doesn't apply in this case.
Dr. Harper testified it did, and that's what experts do.
I would like to have known that, and that was going to be her opinion before today.
Sounds like Dr. Zeus. After this, therefore, because of this.
That's not a change in testimony. That's
Where is that a change in the
You're going to
deposition?
have to read the whole transcript. I asked.
No. This is a 87-page transcript. You're objecting. You have the burden to establish your objection.
Give me a minute. I'll read through it and find where I asked her.
I mean, this isn't the first time I've looked at this deposition. The state provided it to me when we had the hearing on whether or not battered spouse would be permitted. And the state provided specific highlights for me to look at. At no point in time did the defense say, look at this, look at this, look at this in her deposition when we had that hearing. So other than what's being provided to me right now and what's been testified to this morning, I don't know what opinions she has. All I know in coming into today is what the basis of her opinion was, specifically with regard to any of the statements that Ms. Boone had provided, which was the whole crux of the state's motion to prevent battered spouse from coming into evidence.
Judge, if you look at page 66, line 20.
Logical fallacy because when someone assumes an event.
Yes, sir.
Page 66, line 20, question. Okay, so other than the couple of hours that you intend to maybe reflect on your notes and anything else, any other work that you intend to do on this case? Answer 23, no, sir. Not that I'm aware of. Line 24, question. And you've expressed all your opinions, at least generally here today. Answer, page 67, line 1. Yes, sir. Question. Then I go into fees. Then on 67, line 7, question. Just double dog sure. You admit that you have no other opinions other than the ones you've expressed here today. Line 10, answer. That I've been asked about. If I'm asked something else, that I'll offer it. Number 12, question. And you've been provided all the resources you need to rely on and express your opinions. Line 14, answer. I have based an opinion on the resources that I've been provided. If there's other things out there to be provided that may or may not change my opinion. I believe it's a discovery violation because I should have been notified that there was going to be a change in opinions here today. And we had an agreement that I was going to be allowed to retake the deposition and not be ambushed in the middle of the trial with a new opinion.
What new opinions are different based on what Mr. J proffered the testimony is going to be?
I have to ask Madam Clerk to reread the question and the answer from the expert. It's been so long now.
Madam Clerk or Madam Court Reporter, are you able to reread the portion of the proffer as to what Mr. J asked of the witness? Absolutely.
Hello, Mimi. Hello, darling. Hello. Right. I can't even digest that sentence. Not at this time of night. Legal fallacy that occurs when someone assumes that an event is the cause of another event that happened shortly after it, based solely on the order of events. Yeah. That's why it should be stricken. She's given a different answer to what she originally said. She said that she had not been able to formulate an opinion because she needed to review her notes, and yet she gave an opinion on the stand. That's, I think, what the crux of it is.
Court's going to step off for a moment while Madam
Yes,
Court
step
Reporter
off.
is able to provide that readback.
A logical fallacy. I did what I did because of what you did, even though what you did what I did. Okay. All right, let me try and put this into context. All right. I did. Mm-hmm. And what you did came after what I did. So I sneezed because you shook pepper. Even though I sneezed before you shook the pepper. I don't know how to relate it. My brain not compute. Not today. Oh dear. I'm not very clever, am I? I can formulate a battered spouse syndrome defense, but I can't. Oh dear. I can't do a post hoc ergo propter hoc. Sounds like a soup. Ooh, I'm going to cook this really yummy post hoc ergo propter. I know, I comprende. Sorry. That's silly. I was mean to you because you punched me, but you punched me after. Ah, okay. Thank you. Right. I get it. Thank you. I needed it in yeah, you know. I needed an example because I wasn't capoting. Yeah, that makes sense. Nothing? I was going to say here, move along. Absolutely. Yes, I actually think I haven't actually eaten a great deal today because I slept right through till I think it's 5:30 this afternoon. I feel like I'm on night shift. It must have been later than that. I can't remember now. Yeah, so the old blood sugar, I think it might be. That's my excuse, and I'm sticking to it anyway. I don't know what the F they're doing. I might have a little bit of L room. A little bit. No, that's it. All right, let me bring up this jury instruction then. Oh, you watch. The second I bring it up, I'll come back on screen. Just make sure it's big enough. Okay. All right, so this is the standard jury instructions. 3.6F, which is what they're going to be arguing today. I told you, see? Second I put it up, they're back.
Defense.
James Owens, Ms. Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning.
Mhm.
Madam Court Reporter, have you had the opportunity to review the transcript as to the proffer of Dr. Werner's testimony? Okay, you may proceed.
By Mr. J, question. You've been present for all of this hearing, yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no. Question, all right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Question, that it's not related to the incident as she reported it. Question, okay. And if I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. Question, if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
I don't think that's the very beginning before I objected.
What was asked was to read back the proffer.
I thought I was asking to go back to the very beginning when the question was asked and then her response and my objection to it.
What was specifically asked was to the proffer, because
I'm on mute, sorry. So it's the PTSD that alters that perception of fear. So that's why it's important. If she hasn't got that diagnosis, then there's no trauma bond attached to that. So that won't have the same extreme emotional response bonded to that trauma. Does that make sense? So it's important to be able to show that there is a physiological and emotional response to a trauma that's happened in the past, post-traumatic stress disorder. If she's saying she doesn't have it, then it will affect that perception at the time of the event. Does that make sense? If we heard the video, she didn't fear for her life. You have to believe she later feared for her life. Sounds like BS to me. Yeah, I was muted, sorry. Sometimes that's a good thing.
the question before the court was whether the proffered opinions are at odds with what was testified to during the course of the deposition. There's the question that was asked, and the answer that was given affirmatively provided an opinion as to PTSD. I think Mr. J admits that. Mr. J has advised the court that's not what he was hoping the answer would be. The answer was supposed to be something different, as identified in the proffer.
So strike it.
Which is why I had Madam Court Reporter read back the proffer. So the question Mr. Owens posed to you is whether the proffered opinions that Madam Court Reporter just read back to us are different than what was provided in the deposition.
Yes.
How so?
She tended to explain in the proffer some legal reason why it did not apply in her opinion. That was not discussed in any way in the deposition.
Okay. My question is specific as to opinions. Her opinions were as to battered spouse syndrome,
That she didn't have an
post-traumatic
opinion.
stress disorder, and their relationship to the case based on the defendant's responses. The answer is not related to the incident as the defendant reported. Those are the opinions, as I understand them, based on the proffer, as it relates to battered spouse syndrome and post-traumatic stress disorder.
I think I'd refer to page 46. Line 13 was the question, but you don't believe that she suffers from post-traumatic stress disorder in your opinion. Line 15, the answer is no. I would have to look back through my notes to see if she fully met that criteria.
So she hasn't formulated an
explain why you
opinion.
don't think she suffers from post-traumatic stress disorder. Line 19, the answer no. I didn't say one way or the other.
Mm.
I would have to look back through my notes for that. Question number 21. Is that something that you may, in the future, give an opinion about after some time reflecting and reviewing your notes? 24. I may. 25. Okay, and that's something you will let the lawyers know about if that changes. That's on page 47. On 2, yes. That's fundamentally, substantially, materially different from what she's testified as it relates to post-traumatic stress as it applies in this case.
In the proffer?
Excuse me?
In the proffer? She's not rendering an, unless I misunderstood the proffer, she's not rendering an opinion on PTSD and whether or not Ms. Boone suffers from it.
Well, she led me to believe that she was trying to decide whether or not Sarah Boone suffered from post-traumatic stress. Now in the proffer, they're claiming that post-traumatic stress does not apply. I don't know what the initial question was. We haven't had that read back when it was first going on.
I agree.
The question was asked, and I believe she rendered an opinion. And I, again, like that to be reread back. What the initial question was, what the response was, because it didn't. I know I objected. I can't even remember it now. But I know I objected because I knew it was inconsistent.
You asked to approach, and then you explained that the question was it was not something that was framed in the deposition. Multiple times I asked you for a legal objection. And it wasn't until right before or right after we sent the jury out that you provided some legal objection.
Yeah, but he's been
Now,
ambushed.
Madam, if you want Madam Court Reporter to go back and read the question that led us to where we are right now and the answer, I'm totally on board with that. I have a memory of what it was, but nothing like.
Before she does that, can I get the first question of the proffer? If BSS or PTSD has any, can you reread that? So
Let's just reread the entire proffer, just so that it's a clear soup to nuts, alpha to the omega, what the proffer was. Madam Court Reporter.
Alpha to the
be so
omega.
kind. Yes, ma'am.
Mr. J, question? You've been present for all of this hearing. Yes, doctor? Answer, yes. Question, am I misrepresenting any of our conversations? Answer, no.
No, it was before
All
that.
right, so if I ask you if battered spouse syndrome or PTSD has any relationship to the facts of this case as the defendant relayed them to you, what would be your answer? Answer, that it's not related to the incident as she reported it. Question,
It was
okay.
before
If
that.
I ask you, therefore, if there are any prior instances of violence, would that change your opinion? What would your answer be? Answer, no. And question, and if you reviewed any other materials, would that change your opinion based on what she told you about what happened that evening? Answer, no. Question, all right, that's it.
And then if she could go back to the initial,
You just reread what she read before. Yeah. Yes, that's right. Because she hadn't been back. She had to go back over her notes to see. Whereas today, it doesn't matter whether she reviewed any extra material, which it was before that, what she read through. It was before that, because that was just basically the end of his questioning.
Oh, I was waiting on you. Please, go ahead. Sorry. Pay no attention to me. Go ahead. My understanding is it was the question and the answer right before Mr. Owens asked to approach.
No, it was before that.
Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Can you read that for me one more time, please? Both the question and the answer.
Question, what was your opinion? Answer, my opinion was that she did not give me enough information to diagnose her with post-traumatic stress disorder at the time that I evaluated her at the jail.
Maybe we could please have the previous question as well.
Question, and in this particular case, did you require any additional information to reach your conclusion about the relationship between battered spouse syndrome and the events of this evening? Answer. I based my opinion on the information that I had. Certainly, if there was more information, my opinion would be subject to change.
Which is the opposite of what she just said now.
Mr. Owens?
Number one, that question and answer, she gave a differing opinion than what she gave in her deposition, which, subject to the agreement we had, I should have noticed. Number two, with the proffer, it seems that she's going to find that post-traumatic stress disorder did not apply to the facts as related by Sarah Boone. And that is an opinion that I needed to know about. And I asked throughout this deposition and at the very end, some general, if you have any new opinions or anything new that differs from what you've said here today, please notify the lawyers or words to that effect. So it's an evidentiary issue. I've got a right to be prepared for the trial through discovery to know what the witnesses are going to opine. And this is a discovery violation based on two things. One, her initial answer to the question that I objected to, and then two, the proffer is a new opinion. It's a discovery violation. I asked that the witness be stricken.
Any response?
Judge, I think it's clear from my original question that the intent that I stated was the intent of my question, to get the answer that I intended to get was what the question was intended to elicit from the witness. As far as the discovery violations and continued attacks, I'm just not I'm not convinced he understands what the answer means or what it's going to be. The answer isn't going to be Ms. Boone didn't have PTSD, hence, therefore, battered spouse syndrome doesn't apply in this case. What I believe she's going to say, and what I believe I've been saying she's going to say, based on our conversations, was irrespective of whether anybody believes Ms. Boone had BSS or PTSD, it is irrelevant because of what Ms. Boone told her happened at the time of the event. That is not a discovery violation. She was specific in saying, if you have any questions you want to ask me, I'll give you an opinion. That is exactly what she said on page 67 of the deposition in response to a question that starts at line 7. Question, just double dog sure, you admit that you have no other opinions other than the ones you expressed here today. Answer, that I've been asked about. If I'm asked about something else, that I'll offer it. They didn't ask about the interplay of the facts with the relevance of the syndrome. That's them, not the state.
Any other argument?
The totality, if you read that deposition and all that we talked
I
about.
specifically asked you, Mr. Owens, to point out for me
What
excuse me, I specifically asked for you to point out specific portions of the deposition that are at odds with either A, the opinion that was previously given, or B, what was proffered to. You have provided me pages 45, 46 of the deposition relating to specific opinions on whether or not Ms. Boone suffers from post-traumatic stress disorder. Are there any other portions of the depo that you would like to point out for me? I am not going to read an 87-page deposition and continue to waste our jurors' time as we try to find a solution for the situation that is now before us. If there are specific portions of this deposition that are at odds with the opinions that have been proffered and or provided so far, I would ask you to direct my attention to them.
Well, the ones that I expressed.
Other than what you've already identified.
The ones that I expressed, and that just the understanding that we had that she, in the pages that I have talked about previously here today, the pages that I referred to about our agreement, that she was going to let me know if there were any opinions that she had in addition to the opinions that she gave in the transcript.
Okay. All right, thank you. All right. Any other argument, Mr. J?
No, thank you.
Okay, thank you very much. All right, the court has had the opportunity to listen to the proffer as read back by Madam Court Reporter, the read back of the opinion that was previously offered, the portions of the deposition which have been highlighted by the defense specifically pertain to opinions by the defendant as to whether or not the defendant suffers from post-traumatic stress disorder. That opinion is not being offered. The opinion pertains to the relationship of battered spouse syndrome and or PTSD as it relates to the facts of the case as the defendant has relayed them to you, and that they are not related. However, the deposition is identified by the defense, identifies that if there were any additional opinions, that there would be notification. So the court at this point in time, as there has been an alleged discovery violation in accordance with binding precedent by the 6th District Court of Appeal, which is binding on this trial court in Young v. State, 369, Southern 3rd, 1243. At pinpoint 1248, the court is now going to conduct a discovery violation or discovery Richardson hearing. State any other arguments with regard to the elements of a Richardson hearing?
No, sir.
Okay, thank you. Any other arguments with regard to the elements of a Richardson hearing, Mr. Owens?
None other than I understood she did give an opinion about post-traumatic stress in that initial series of questions.
Okay. All right. The court, again, reviewing the proffer and the opinion, finds that the state's violation was inadvertent based on the proffer by the state, which was agreed to by Dr. Werner as to the conversation they had last night, as to the opinions and whether or not that they had changed. However, I do find that that violation is substantial with regard to the opinions based on the testimony in Dr. Werner's deposition that any other additional opinions would be notified to the defense. As it relates to the third category, the effect on the defendant to properly prepare for trial, although the questions in the deposition as highlighted by the defense so far do not address the opinions being currently offered, I do find that it had some impact on the ability for the defendant to properly prepare for trial. As it relates to the opinion that was previously provided as read back, specifically my opinion was that she did not give enough information to diagnose her with PTSD at the time of the evaluation at the jail. What is your position, if any, with regard to that opinion now that the jury has heard it? Mr. Owens. Because my question is, do you want it struck?
Yes. Yes.
On that issue, we'll address it on cross-examination.
So you do not want it to be struck, and you do not want a curative instruction.
Well, I'm going to question her about post-traumatic stress, so it's going to come out through my cross from the deposition about what she said, and then it's inconsistent with what she said here today, so I'm going to want to rely on that question or that answer.
Okay. All right. Ms. Boone,
No,
have you been paying attention to the questions and answers and the readbacks of both the proffered testimony and the opinion testimony?
Yes.
And are you on board with the strategy not to seek to strike that opinion?
Yes.
Thank you.
Is that right? If I understood the concept here, so he's now looking to impeach her testimony. Is that because if he strikes it from the record, then he can't go back and impeach a prior inconsistent statement? Is my brain starting to work yet? Somebody help me. Is that where the train's headed? To that station, impeachment station? Yes. Soup to nuts.
With regard to the proffered testimony, I'm going to permit now in open court, and I will oversee the deposition for you, Mr. Owens, to inquire as to those opinions.
I'm sorry.
With regard to the proffered opinions, the
All
court
right.
will oversee a deposition now, and you may proceed.
Right now?
Yes. With regard to the proffered opinions. And I believe that will provide a cure for the discovery violation under the Richardson violation
Cool.
based on your request not to strike the prior opinion. And since you're going to utilize that on cross, I find that the prejudice is limited. But with regard to the new opinions, I will give you the opportunity to depose her now curing the prejudice at that point in time. You may proceed.
Dr. Warren.
Yes, sir.
Good morning.
Good morning.
At some point, the state attorney notified you that you were to come today.
Correct.
Did you and the state attorney have a discussion about your testimony?
Yes.
When was that discussion?
Briefly last night.
So y'all talked on the phone last night?
Yes.
Have y'all had any discussions since the phone conversation last night?
Briefly this morning.
And how long was the phone conversation?
Less than 5 minutes.
How long was the face-to-face conversation?
Less than 5 minutes.
Did y'all discuss that your testimony would be that you did not have enough information that you gathered from Sarah Boone to form an opinion as to whether or not she suffered from post-traumatic stress disorder?
Correct. That my opinion hadn't changed.
I'm sorry?
Yes, that my opinion hadn't changed, that I didn't have enough information.
Okay.
Formulate an opinion.
And did the state attorney speak to you about that it didn't matter whether you had an opinion if you didn't feel like the facts that Sarah Boone had given you as it relates to the facts and issue in this case, that you didn't, if you didn't feel like post-traumatic stress even applied, then you could answer that way?
Correct. That was my opinion. Correct.
But did he present that to you initially for you to form an opinion about it?
No, my opinion was that it didn't apply because of the way that she described the incident to me.
Was that your opinion back when I took your deposition?
Yes,
When did you form that opinion?
when she described the incident to me.
Why didn't you let us know that was your opinion at the time that I took your deposition?
You didn't ask me about that, sir.
Do you remember me asking you any other opinions that you may have as it relates to this case?
You didn't ask me specifically about that.
I understand that, but you're saying you formed that opinion prior to the deposition, correct?
Yes. The state attorney and I discussed that on the way out of the jail, as a matter of fact.
After the deposition?
No, sir. After the evaluation.
Okay.
On the way out of the jail.
All right. And I asked you, were there any other opinions that you may express at trial after you had discussed that with the state attorney prior to the deposition? Is that correct?
Yes.
And so you were aware that I didn't want to be ambushed at trial. I wanted to know any and all opinions that you may be expressing in the Sarah Boone case.
I didn't know what specific information you wanted, sir. That's why you
Have you not testified as an expert witness before?
I don't know what all information you want me to provide to you.
So because I didn't ask you specifics, you felt like you didn't have to respond specifically.
No, sir, I answered all of your questions. And as I said, I'm happy to answer any questions that I'm asked. I don't know what questions you want me to answer.
But you know that this was a central issue in the case. Did you not? Your opinion
Yes,
is relating to a central issue in this
Yeah.
case.
correct.
You're aware Sarah Boone's on trial for murder.
That's
And you had this opinion when I was taking your deposition, and I was asking you specifics about any opinions that you may be expressing in the trial of Sarah Boone, and you did not disclose it.
Well, I told you that I would answer any questions that were asked of me. I have a number of opinions. I know that I don't feel that she's suffering from major depressive disorder. I didn't offer that opinion either. I have a number of opinions.
That's all.
Which she should have told that too. What the
Mr.
fuck?
Jay, anything else?
I'm just making sure you want to inquire,
This is your opportunity, Mr. Owens.
because that was more just about.
Inquire about what?
This is your opportunity to inquire. You are conducting a deposition. This is your opportunity and your only opportunity to cure any prejudice that we've identified with regard to those proffered opinions as it relates to the relationship of battered spouse syndrome and or post-traumatic stress
We
disorder
didn't have an opinion to
as
start with.
proffered.
The problem is now, Judge, is I've got my expert, and we weren't aware. You know how in these type cases, the experts are allowed to listen to the testimony of the other experts and read the depositions of the other experts. Dr. Warner, were you given the opportunity to read Dr. Harper's deposition?
I was.
I mean, that's standard operating procedure in these type cases. And now I'm taking a deposition on the fly, and then I
No,
haven't had a
and-
chance to speak
About
with
it.
my expert about those opinions
Mhm.
and whether or not that would change her opinion. It just puts me in a very difficult situation, but if I'm ordered to continue the deposition, I will.
That's that's your decision. It's not an order. I'm just saying that this is the opportunity to cure that Richardson issue. You asked previously to strike the expert. I am disinclined to do that. The case law says that is an extraordinary remedy, one which I am not going to permit.
Dr. Warner, you realize you're in a courtroom
Yes, sir.
and we're waiting on the jury on the trial of Sarah Boone.
Yes.
Are there any other opinions that you intend to express in this trial that you have not disclosed to me in the deposition, or you have not disclosed here today under oath?
I'm happy to answer any questions that I'm asked.
Are you refusing to answer my question about any other opinions that you
He's
intend
being
to
very
express
evasive.
here today as it relates to Sarah Boone, who was on trial for murder in the second degree?
Judge, I'm going to object. The catch-all vague question that Mr. Owens wants to ask this expert witness
No,
about
vague
any
answer.
opinions she may or may not have. 99 out of 100 attorneys would come in here and say, that's not how you do depositions with expert witnesses. You have to ask specific questions. Anytime you ask a question like that of an expert, the expert is always going to say, please ask me a specific question. And that's what she did then. That's what she's doing now. It's unfair and vague to ask somebody, tell me every opinion you have.
Judge,
Yes, sir.
we're in the middle of a trial. She's fixing to testify. She's had conversations with the state attorney. She
Mhm.
knows what she's going to be asked in forms of opinions that she's going to express. That's why she's here, to help the jury understand the science that relates to the law.
She didn't have
and
an
express
opinion
opinions.
one way or the other in her
And for me to
deposition.
ask, we're playing hide the ball here? In the middle of a trial,
I disagree that there's any hiding of the ball. There's been a proffer. It's been
No,
read
there's
multiple
only
times
symptoms.
as to the scope of the opinions regarding to battered spouse syndrome and post-traumatic stress disorder and its relationship to the facts of the case as the defendant represented them. And the answer is they are not relatable to the incident as relayed by the defendant. That is the opinion that have been proffered.
all right, can I continue with my deposition?
Yes, sir.
Dr. Werner, do you recall expressing that you wanted more time to reflect as to whether or not
Hmm.
Sarah Boone suffered from post-traumatic stress disorder?
Yes, that I was going to review my notes to see if I had enough information in there to support or negate that.
All right. What additional information would you need for you to express an opinion that she suffered from post-traumatic stress disorder?
So she did not give me information regarding the presence of intrusive symptoms. She didn't give me information regarding persistent avoidance. She didn't give me information regarding alterations in arousal or reactivity.
Anything else?
No.
Would you agree you failed to ask her those questions?
I asked her if there was any other important information that she felt like she needed to share with me at the end of my evaluation, and
It
she
was a
said no.
rushed
So a catch-all question.
evaluation.
Correct.
Were there any other personality disorders? Isn't that what you do as a psychiatrist? You diagnose an opinion, express opinions about whether people suffer from personality disorders?
Correct.
Are there any other personality disorders that you have formed opinions about Sarah Boone that you intend to express?
No.
So narcissism, you did not find.
I found narcissistic traits.
In terms of your opinion that she suffers from narcissistic personality disorder.
No, sir, I said narcissistic traits.
Okay. So you don't have an opinion that she suffers from narcissistic personality disorder.
Correct. She displays narcissistic traits.
Mhm.
You expressed an opinion that she suffers from alcohol use syndrome,
Alcohol use disorder.
alcohol use disorder.
Correct.
Is that still your opinion?
Yes, it is.
Yeah, exactly.
Anxiety disorder. Is it your opinion she suffers from the anxiety disorder?
No.
Do you recall in your deposition indicating that you felt like she suffered from either anxiety disorder or adjustment disorder?
That's correct.
And you've changed that
That's
opinion
different.
now?
I'm leaning towards the adjustment disorder secondary
Leaning
to her
towards
situation.
the fuck.
So
an
you
expert?
haven't formed an opinion as to whether or not she suffers from general anxiety disorder or
This is
adjustment
bullshit.
disorder?
Correct.
She shouldn't be allowed to testify. This is bullshit.
You agree that she suffered from trauma as it relates to the domestic violence history that she expressed to you from the intimate partner violence with Jorge Torres?
Yes, as reported by her. Yes.
Do you have anything to dispute that?
No.
As reported by her, did she not go over the medical history, the pictures of the domestic abuse, the injuries? It sounds to me like she's done a half-assed job at 4 days before a goddamn trial, and she has no idea. But the prosecutor's putting pressure on her because they need to put up an expert.
In your opinion, does she suffer from any form of psychosis?
No.
Is it your opinion that Sarah Boone suffers from acute stress disorder?
No.
Is it your opinion that Sarah Boone suffers from intimate partner violence?
Yes, I think that there is enough history to
What's the difference then?
of the volatile relationship between the two of them.
Because of that, do you believe that Sarah Boone suffers from battered spouse syndrome?
She may meet the criteria for that.
May.
May.
She may?
So it's possible?
Yes.
Is that your opinion?
Yes.
Definitively, you can't say?
Oh,
There's a history of her having that. Yes.
So you agree she suffers from battered spouse syndrome?
Yeah.
it's not what she said before.
I believe we've covered anxiety disorder, narcissism, battered spouse syndrome, and alcohol use disorder. Are there any other opinions that you intend to express as it relates to that or any other
Affect disorder?
psychological condition of Sarah Boone?
No.
That's all the questions I have.
I'm sorry, but that differed completely.
Any other arguments at this time?
No, Judge, just the one I've already made.
Okay, all right. The court has conducted its Richardson hearing and made its findings. The court, as previously identified, will not strike the expert as that remedy is quite draconian, and I will not do so based
Draconian.
on the questions that were asked as highlighted by the defense and the opinions that were offered. The specific areas for which opinions are being offered were not inquired into, but the deposition did leave it open that I'll ask questions about any other opinions that I'm asked about or anything else that I'm asked during the course of the trial, specifically page 59, 22 through 26 on 1,
You
page
can
60,
elaborate
lines
on
11 through
what
25. So in the abundance of caution, the court has permitted that in-court deposition. Anything else, sir?
No, sir.
State, anything else?
No, sir.
All right, let's go ahead and bring back in our panel and we can,
Before we bring the jury back in, may I approach Mr. Cacciatore on a completely unrelated matter?
does it need to be on the record or?
Yes, it does.
Okay, go ahead.
We would concede that Detective Copsell and Detective Lowen are not testifying against us here in court this morning.
They're still under defense subpoena.
I
We have
asked,
not,
I asked Mr. Henderson if you guys were calling Capsule again, and he said no.
and we're not in our defense, our direct defense. Is there a possibility that based upon the information the state is going to present today or this afternoon, that we may want to receive or seek rebuttal, and possibly through these witnesses? They're under subpoena, and I'm sorry, Mr. Henderson's not here. I've just noticed their presence. Out of an abundance of caution, I think that we need to clarify for the record that they're here listening to.
What's your base? Well, we're off the record. There's no jury here. That's fine. You all stay where you are. What's the basis for your sir rebuttal?
We don't know because I don't know what the state's going to place in a rebuttal. But
That doesn't answer my question. What's the legal basis of a sir rebuttal?
Judicial discretion as to the fairness of the proceeding that the defendant pursued.
Okay. Anything else, Mr. Cacciatore?
No, Your Honor.
Okay. The rule of sequestration is still in full force and effect. Detectives Lowen and Kepsel, good morning. I'm going to ask you to be excused from our proceedings and not view them and not have any communication amongst yourselves about testimony that has been previously given or any questions that have been asked or answered, and just keep your separate ways as it relates to this case and any questions or testimony that you intend to give, may give, or have give, and to comply with any instructions that were provided to you by the state regarding the rule of sequestration. Thank you very much. Anything else, Mr. Owens, we need to address?
No, sir.
Anything else, state?
No, Your Honor.
All right, let's bring back in our jury. You can continue your inquiry, sir.
So someone explain to me what that means. He's allowed the deposition in, so he's also allowing the cross-examination of this witness by the defense to impeach her as well. Is that? I'm confused. I don't know who won that argument by that answer. Mm. Well, let's put it this way. This is going to make for a really, 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 really good podcast on Saturday. Why is it flying? Steve, I hope you're watching this and taking notes. Copious amounts of notes. Actually, I probably should be making notes so that I can remind him.
Bless you.
Every time the judge does that. Must be hard being a judge when you have one belief but you can't rule on it because of legal precedent or case law, or they haven't presented a legal argument to back it up. You can't fight their case for them. But I do think he was ambushed there.
State, you recognize our jury.
Yes, Your Honor.
That's, you recognize our jury. I thank y'all. You can be seated. Members of the jury, thank you again for your patience. We had some issues I had to address with counsel outside of your presence, and we're going to continue the state's rebuttal case this morning. Again, if you could please just raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. Mr. J, you may continue your inquiry, sir.
State would move to strike the last response as non-responsive.
Approach.
Oh, you fuck. You fuck. After all that, on the record, he comes back with that. Is it just me? It's not just me, surely. He waited until it went back on the record because he doesn't want his witness impeached. Am I making the right assumption here? My conclusion, is that correct? Is that what?
Your objection's overruled.
All right. Irrespective of whether anybody has an opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone and what she relayed to you about the facts of the case, does PTSD or BSS have any relation?
Objection, that's an asked and answered.
Overruled.
No.
And what particular part of her statements about the incident is that?
The whole part where she's describing the part about playing hide and seek and that they were having a good time, they were laughing. When he got in the suitcase, when she found him, they were enjoying themselves. She zipped him up. They were still laughing, having a good time.
They were
All
still
that isn't
laughing.
consistent with her having a feeling of she had imminent risk or imminent, there was an imminent risk of harm that she needed to protect herself.
Can we proceed?
Yes.
At that point in time, she didn't. Can someone help me here? Someone who knows a little bit more about the legality of this. Help me explain what I'm missing. So obviously I'm missing something because I think the state is driving a freight train to Kansas and I don't know. Yeah, I don't think that she's credible at all. Not prepared to commit to an opinion at one point. Doesn't think that her opinion would change if given any further information on it, even though that information could be pertinent. Just described that there is 3 phases to this. There's the build-up phase, there's the battering phase, and then there's a honeymoon phase. So you're not always going to be in that state of imminent fear. Yeah, I am. Please explain. Someone help me. I don't understand. I don't understand the legal. I can pick up when someone's talking bullshit, but the implications of that is where I lack. Please explain. What he just did about putting that on the record then and trying to strike, was that a dodgy, an ass move? So that he couldn't, the state couldn't, the defense couldn't then use it to impeach her. Am I making the right assumptions, or because that's where my brain went. She ain't happy. She's not a happy camper. We're going to argue about this all day, so we're not even going to get to closings today. Are you happy there, mister, are you? I can hear you. Yes, you're purring away. Yeah? Yeah? Ooh. Purr, purr. Ooh. That's such a loud purr. Gee. I would take notes, but... Oh, I'm coming back. He was on my notepad.
Members of the jury, I have something I've got to discuss with counsel outside of y'all's presence. Same instruction. Please don't conduct any independent investigation or research on the person, places, thing, or charge involved, and don't have any conversations among yourselves or anyone else with regard to that, and we'll bring you back in as promptly as possible. Thank you.
Hello, madam. How far art thou? This case has turned almost on its head. It's completely. Have you been watching? Because I've muted it. Hang on.
Madam Court Reporter, when you're ready.
Yeah. And the credibility of their witnesses as well. I just think the state has rushed this at the last minute to try and obviously get a different opinion from an expert, and in doing so have rushed it and botched it and either not provided her with all the information, or I don't know. I don't like it. I just don't like it. Doesn't sit well with me. I don't understand how she can say that she didn't provide me with enough information about previous trauma. I still think conviction is likely, just my personal opinion. I believe the evidence is too compelling, even though chicken cacciatore is doing. Yeah. Look, I agree. There is a level of culpability there. I am just not decided as to what level that is, whether they have reached second-degree murder level or involuntary manslaughter level, and what impact that may have on the outcome.
Yes, ma'am. Just read it from the question, answer, question, objection. Let's just have the we can buttress it.
So they're going over it all again, are they?
Go ahead.
By Mr. J, question, all right. Irrespective of whether anybody has any opinion about whether Ms. Boone is suffering from PTSD or DSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD or DSS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, and what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek, they were having a good time, they were laughing. When he got into the suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having a good time. All of that isn't consistent with her having the feeling of she had imminent risk or imminent risk of harm.
She admitted that at the start. That's not
Any other argument,
unconvincing.
Mr. Owens?
That was before the overt act.
That invades the province of the jury. That's a decision whether or not she had imminent risk of harm or perceived an imminent threat is a question for the jury. This expert can express opinions on science, on medicine, but not on the ultimate issue of fact, and explain to the jury that this defense doesn't qualify, that you should rely on me as an expert, and I'm going to make the decision for you, ladies and gentlemen of the jury, by telling you that under the facts expressed to me by Sarah Boone,
Yep.
she was not.
I've made a
perceiving
conclusion.
threat at the time.
Yep.
Response.
I'm sorry, but I have to agree with him.
An objectionable opinion. It's not an opinion on the ultimate issue. It's an opinion
Oh,
on
shit.
the applicability of a particular set of evidence that testimony that the defense has offered, called battered spouse syndrome, to kind of help explain a portion of the justifiable use of deadly force or non-deadly force instructions. She's not up there saying Ms. Boone was unjustified in doing what she did. She is not saying that justifiable use of force doesn't apply. What she is saying is, in her opinion, based on the facts that she relies on, given by the defendant herself just a couple of weeks ago, that this particular set of testimony and evidence that has been offered through their expert, Dr. Harper, doesn't apply. This is no different than one expert coming in and saying, well, yeah, you can know that the defendant was sane at the time, despite his mental illness, because he ran from the police, he hid, he concealed evidence, so on and so forth. And therefore, because of those facts, insanity doesn't apply. And a defense expert may come in and say, well, insanity does apply because my client, after stabbing her mother to death, called 911, was speaking unintelligibly and singing, and greeted the officers at the door with a pair of knives and wouldn't drop the knives and was incoherent for 12 hours after the offense. Therefore, based on those facts, the expert says, well, insanity does apply. It's not becoming a lawyer. It's not becoming the juror. It is explaining a particular type of expert testimony. And it just happens to disagree with Dr. Harper's. And Dr. Harper came in and said that BSS does apply and that she was in constant fear. And the reason she's in constant fear is because of all the past episodes and whatnot. It's permissible testimony.
Any other argument, Mr. Owens?
That's totally wrong.
Hmm.
The prosecutor claims Dr. Harper came in and said BSS does apply. That's true. But he just got through saying and trying to get the witness to say BSS,
It's irrelevant.
it's not to be regarded. Post-traumatic stress is not to be regarded. It doesn't even come into play. Post-traumatic stress disorder, battered spouse syndrome does not even come into play because at the time she was facing, according to this witness, no imminent risk of harm. Therefore, you can discount everything you hear, ladies and gentlemen of the jury,
Yeah.
about battered spouse
We
syndrome.
don't know
How
what
does that
this
have
jury
anything
would
to
have.
do with whether or not it's an improper legal opinion under 90.703?
It is. It's the ultimate issue of fact in this case.
And that's for
Because
the jury to
self-defense has
decide.
been alleged by the defense. And the issue for this jury is whether or not Sarah Boone had the right to defend herself
Mhm.
with force, deadly force or non-deadly force, based on her beliefs and
Her own,
impressions at the time, whether they were reasonable under the jury instructions, under the special jury instructions that are going to be applied for battered spouse syndrome, under the jury instructions, under justifiable use of deadly force, whether her perceptions about the threat was imminent and whether it was appropriate or reasonable to act the way she did. This expert is trying to say that she was not facing imminent risk
Yep.
of harm.
Yep.
At the time.
Thank you both for your arguments. Court is going to overrule your objection, find that it is not an ultimate issue of fact as addressed by 90.703. The court specifically relies on Dinkins versus State 976, Southern 2nd 660 at pinpoint 661. In that case, a psychologist testifies in the instant case in Dinkins, the psychologist's opinions were not legal conclusions. The psychologist did not opine on the defendant's guilt or innocence. Rather, the psychologist opined only as to whether the victim was, quote, mentally defective, end quote, and capable of consent to intercourse. Although the opinions did go to ultimate issues in the case, Florida law, expressly provides that an expert witness may render such opinion, see section 90.703 Florida statutes, which provides that testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. Thus, the jury had the power to accept or reject the opinions and was not bound by such. For those reasons, your objection is overruled.
Madam Court Reporter, I'm just going to ask you to read the question and the answer, and then I have no further questions of the witness.
Okay, thank you.
I'm sorry.
He is going to have Madam Court Reporter read back the question and the answer, and then he is going to have no other questions for this witness.
I object.
Basis.
It was asked and answered.
Overruled. There was a pending objection. I'm allow the state to re-ask it so it's clear based on that objection.
Judge, it's 11:30. I'm going to be at least an hour for my cross-examination.
We're going to begin your cross-examination after we're done with after the state advises the jury in open court. There are no more questions. Let's go ahead and bring back in our panel.
I just want to have a look at something because I'm sure there was some case law in here somewhere. Maybe it wasn't this one. Maybe it was this one. Most recent cases continue to demonstrate the ways in which the use of battered spouse syndrome may shape judicial interpretation as it pertains to self-defense, particularly about the imminency of the threats. In State v. Peterson's 2004 Maryland appellate reported the use of battered spouse syndrome as a defense for a defendant who shot and killed her abusive husband whilst he was watching television. Specifically, the Court of Special Appeals noted that the husband had been threatening to kill the appellee on a daily basis and taunting her with details about how he would carry it out, even though he was not assaulting or threatening her at the time when she shot him. The court found that the chronic nature of this abuse, as in her statements, that he would not kill her when she shot him, supported a strong inference that the defendant was in fear of imminent harm. The appellate court affirmed a decision to grant post-conviction relief to the defendant, ordering a new trial, partly due to the defence's counsel failure to introduce the battered spouse syndrome evidence for the purposes of the defense of imperfect self-defense. Defendants who can demonstrate the proximity of intimate partner violence and its influence on their alleged crimes may be more likely to succeed with duress defences related to battered spouse, or courts may be willing to at least consider this evidence in criminal proceedings under these circumstances. So that to me says that she doesn't have to, like, she's not going to be in that hyper super, like that extreme emotional state all of the time. There is components to it. And yes, at that time, they were both smiling and laughing. No one's disputing that. It's her perceived threat of imminent harm after that, after the overt act. I don't see how that witness can say that. I don't know what I'm trying to explain, but I think they're full of shit. I don't like it. I just hope that that Mr. Owens can make her look like the dick that she is. Sorry. I'm not saying that because I believe more one side or the other. I just disagree with this witness.
State, do you recognize our jury? Defense, do you recognize our jury?
Actions of the
You may be
state,
seated. Thank you.
regardless of what the underlying issue is.
Members of the jury, again, if you could raise those hands. Juror number 2, back right, he gets it. All right, thank you all very much. Record reflect, all hands have been raised. State, you may proceed.
I just think they're being dodgy at the end of the day.
Madam Court Reporter.
Question by Mr. J. All right, irrespective of whether anybody has any opinion about whether Ms. Boone was suffering from PTSD or BSS, irrespective of that, based on your evaluation of Ms. Boone, what she relayed to you about the facts of this case, does PTSD and BSS have any relation? Mr. Owens' objection, asked and answered. The court overruled. The witness, no. Question, in what particular part of her statements about the incident is that? Answer, the whole part where she's describing the part about playing hide and seek. They were having a good time, they were laughing. When he got
They were
his
drunk.
suitcase, when she found him, they were enjoying themselves. She zipped him, they were still laughing, having had a good time. All of that isn't consistent with her having a feeling of she had imminent risk or imminent risk of harm.
No further
At
questions.
that point in
Any
time,
cross-examination? You may proceed, sir.
Dr. Warner, good morning.
he's pissed. Don't blame him. She's not psychic. She can't get.
What all did you consider collaterally as it relates to your opinions you're expressing here today?
I had a number of documents that I reviewed. I'll look at a list. I had the Orange County Sheriff's Office investigation report. I had a transcript of a 2-hour interview of the defendant. I had a
That's the 2-hour interrogation with Detective Lowen and Detective Copson.
It was an interview, yes.
Excuse me?
Yeah.
Okay, go ahead.
It was
labeled
an interview.
Then I had a transcript of a second interview the next day of Ms. Boone. I had medical records from Aspire Health and Advent Health. And then I had some cell phone records.
That's it.
And I also received the deposition.
What about the video of the suitcase?
Deposition of Dr. Julie Harper?
Yes.
Okay. And did you listen to Dr. Julie Harper's testimony in this trial of Sarah Boone?
No.
Do you agree you have a right to do that?
Yes,
And did you listen to Sarah Boone's testimony in the trial of this case?
No.
You agree you have a right to do that?
yes.
You elected not to listen to her testimony before expressing opinions here today.
Overruled.
I did not have time to do that.
Not have
Oh,
time to do that?
Correct.
She's on trial for murder.
and
Yes.
you didn't take the time.
Sustained.
Yep.
You said you considered some text messages from Sarah Boone's phone.
Can you be more
I
specific?
reviewed them, correct.
Would it be fair to say that of those text messages, they're not necessarily overly relevant?
Yes.
She didn't even mention she saw the suitcase video. Isn't that like the most important bit too? Like, it smells of a half-assed job. Sorry. In my opinion. She couldn't even say, she just said an interview. She hasn't put any effort at all into this evaluation whatsoever.
Regarding these text messages that you were provided, did that inform your opinion that you just expressed about the inapplicability of BSS or PTSD to the facts of this case?
No,
Did it apply to your opinion that Sarah Boone suffers from battered spouse syndrome?
no,
Are that information, when you express opinions in court about a patient or about an individual, you rely on your personal assessment as well as the documents and evidence that you're provided and asked to review, are you not?
correct.
And in this case, your testimony is that you reviewed all that information before you interviewed Sarah Boone for 2.5 hours on October the 2nd of 2024, 22 days ago.
Correct.
So you had the information,
Yes.
the documents, you read the documents,
Yes.
you read all the text messages,
Correct.
and you are going to express some opinions here today, are you not?
Correct.
You're going to express some opinions about narcissism, whether or not she had.
Yes.
Mhm. Oh, I've got L room. Oh. I'm not loving this. Maybe I should take some screenshots of her funny faces and put a compilation together. This is what it looks like when you suck a lemon. Get off. Hopefully the jury's picking up on all this. All right, we're live again. I've L'd it out. I'm out of L's. Actually, I probably should